Good afternoon, or good morning, or good evening, dear participants. Thank you very much to everyone who joined or will join our discussion today. It's my honor to welcome you today to the chat that we have today about the future of international arbitration. This chat is organized within the framework of WIS Global's 2021. First of all, I would like to thank the Russian Institute of Modern Arbitration and Young IMA Initiative for organizing this event and inviting me to join the panel as a moderator. First of all, I would like to say thank you very much to our guest speakers today. I am very happy to introduce really very much distinguished and really two stellar arbitration practitioners who joined me today for this chat. It's Anna Jobin-Bre, Director of UNCITRAL. Thank you very much, Anna, for joining us today. Great to see you. And it's Gary Bourne, partner at Willem law firm and the author of third edition of International Commercial Arbitration textbook and one of the most prominent arbitration practitioners in the world. My name is Andrei Gorlenko. I am partner at Russian law firm Ivanian and Partners, practicing commercial and investment arbitration, and also the president of the board of Russian Arbitration Center. And today we would like to talk with our guests about very interesting topic, and I think the topic that is very interesting also for specifically young practitioners, I think, who will be very active, and I'm sure they will be very active in 10 years in the international arbitration landscape. And that's why I'm happy that this chat is happening in the framework of the WIS Globals. So the topic of our chat is Arbitration 2030, Sculpturing the New Tomorrow. Well, I think, first of all, I would like to say that we're discussing this kind of topic with these exact numbers, 2030, with the colleagues from Russian Arbitration Center, I think somewhere in the middle of 2019 or in the end of 2020, when no one has heard about COVID yet. So for us, it was an interesting topic, but for sure, we couldn't even imagine that what will happen next in 2020 will make us maybe closer, or maybe someone will think we will talk about this not so close to the future, to this 2030. So then this 2020 happened with all developments that we had in 2020. And I think this topic became even more interesting for us. Thinking about discussion that we had, I think, a year ago in the beginning of the pandemics, and I remember that we had also one of the sessions with Gary, for example, last May. I think maybe our thoughts were more dramatic at that time. So maybe we thought that the future will come quicker. And now from 2021, we see that maybe it's not so easy. So maybe it's more complicated issue. But still we see that the landscape is changing rather rapidly. And for sure, the international arbitration landscape is changing and will be changing. For sure, we are now, on the one hand, we are far away from each other. We cannot travel to each other. We cannot see each other as it was, for example, 1.5 years ago. On the other hand, we can meet easier and more often via video conference like we do now. Although it will never substitute the personal talks that we've had previously, but still it's something that we also get benefit of. And I think now, for example, when I'm speaking about international arbitration, it's sometimes easier to tell the client that including arbitration clause for example, SIC or some other arbitration institution that seems for example, Russian client far away. Now it seems not so far away in this digital world, I would say. So it's now more clear how you will talk to counsel if you need, for example, local counsel that is far away from you. It's no one is, or just not so many people are afraid of this. And we see that arbitration as a flexible system is adjusting properly to this new situation. On the other hand, we see that, for example, state courts are also adjusting, at least in some jurisdictions, and maybe we can also talk about this and we can share your views on this. But I think it's good because this kind of good competition, it's only for the benefit of the users of arbitration and of dispute resolution methods. Maybe you also see this kind of developments, positive developments in other spheres of alternative dispute resolution. So now I would like to give floor to our guests and maybe as a starting point to ask how, in your view, arbitration is changing in the post-COVID world that is obviously more digital, more online. How do you think the dispute resolution is going to evolve in the more digital economy? Because we also see that the shape of the economy and the structure of the economy is changing. And what do you think about the tools that are available now for the parties, for arbitrators, for arbitration institutions in the post-COVID era? So first of all, I would like to give floor to Anna, please. Thank you very much. We'll be happy to hear.
Thank you very much, Andrei, and I'm very pleased to join you for this fireside chat. It's lacking the fireside, but the fire is definitely there, at least the passion for international arbitration and international trade law. So I hope to share a little bit of that with those who will be listening to us. And I would like to thank the organizers for having invited me in my capacity as Secretary of Ansitrau to take part in this very interesting online event. So what I would like to say is that very early on, and you mentioned that you had a meeting last year also taking stock in the early days of the COVID pandemic on the changes it was introducing into various areas of the law and also into the arbitration practice. Very early on in July of last year, during our commission session, we had a series of webinars where we discussed the impact of the COVID-19 pandemic on various areas of Ansitrau's legislative mandate, and we looked particularly into what was changing very rapidly in a very efficient way to adapt to the pandemic in international arbitration. And what I would like to say is that I consider that COVID-19 has shown how adaptable we are in all our human activities. We've managed to adapt quite well. And no surprise here, the arbitration industry has adapted also very quickly. And but I see this more as a boosting effect that COVID-19 has had, rather than a revolutionizing effect, because many of the elements that have been used to adapt to the COVID-19 pandemic were already there, simply they were not used. And I would like to draw a few examples here. For instance, in the early days when I was sitting as arbitrator, we used to circulate the final award for its signature manually from one arbitrator to the other. And it wasn't just a practice to use your digital signature, your electronic signature, in spite of it being something that Ancitral had been regulating over 20 years ago, the use of electronic signatures as a means of authenticating the signature is being there in international trade for many years. Similarly, remote hearings was, of course, the most visible change in international arbitration, whether commercial arbitration or investment arbitration. But you could see really that it wasn't that difficult to switch to these remote hearings because the facilities and I would say the framework was already there, and it was already allowing for these kind of remote hearings. For instance, there was no need to change anything in the Ancitral arbitration rules to allow for remote hearings, and similarly for remote participation of witnesses, cross-examination of witnesses through Zoom or WebEx. And taking of evidence. So I think that there was already a lot that was there, but it was not used. The law community is rather conservative, so I'm not surprised here that it took a boost such as COVID-19 to get us, to move us literally from bundles and bundles and bundles and boxes and boxes and boxes of documents into a small iPad in which we have everything and on which we can work as efficiently, listening in several languages on a platform to pleadings, deliberating with colleagues, hearing witnesses. So all of this, I would say, has blossomed with the COVID-19 because we had no other means, but it was really a boosting effect more than a revolution. What I find now is that indeed after a year of being in this situation, there is a lot of stock taking that is necessary to see what is working well, what needs improvements, what could be embedded into rules or protocols. For example, there is this sole protocol on remote hearings, which was launched before the pandemic by a team of lawyers based in Seoul, which came very handy when the pandemic started because we could see that there was something to build on. But what I would like to say is that beyond the COVID-19 pandemic, it has also made us think and made us work on assessing I would say the enabling, but also the disruptive effect that all this digital technology can have on our area of work. There is a lot out there, so we had already a lot available that we weren't using. COVID-19 has boosted it, so we are now more and more familiar with all this technology as supporting our activities. But what I see also is that it has turned us or has focused us on these technological developments, this digital revolution that in this case is really a revolution and not an evolution, and that is really impacting sometimes by facilitating, but also sometimes by disrupting our arbitration practice. And this is something that in my view needs that we look into it a bit further, notably on the impact of artificial intelligence. For instance, there are some areas where it's a no-brainer that AI is going to be, having a machine doing things instead of having a pool of interns doing documents, reviewing documents, going through pages and pages and pages, researching cases, etc. This is something when the machine has learned how to do it, it can be done as efficiently, I would say. Maybe I should be a bit careful here, but could do it very well. And I was at a law tech forum a little bit more than a year ago in New York, I think in February of last year, where I was shown some of the innovations in case management, in even in document management in through AI, and it's absolutely amazing. And I hope that the arbitration community will also embrace these new developments. And but I think we will have time to discuss it a bit later, that this should not be done at the expense of fundamental values and fundamental core and key elements that arbitration, that is part of arbitration, and that should be preserved all through this revolution and evolution.
Thank you very much, Anna. Yes, indeed. I also noticed that the legal tech is developing rather rapidly. Yes, and indeed. So I think something that was, I think 5 years ago, they needed 2 or 3 years to change some system or some software, and now they're changing it within a few months. Yeah, so it's really boosting effect, and I think this boosting effect is a very good word that you used, saying what actually happened with us during the last year. The question is whether this boosting effect will have a long-lasting effect, or it will be not so long-lasting, and maybe the vaccination will have another effect on this. Yeah, so that as you said, the society is rather conservative, and maybe vaccination will bring us back to old rules and to old habits. So I would like to ask Gary, what do you think about this? How you see, how you evaluate those changes a year after it all has started? Maybe you don't like something. Maybe there is some negative aspects, or maybe I'm wrong and maybe it's only positive, and you are also optimistic about long-lasting boosting effect, as Anna said, that will continue and bring us to very good arbitration future in 2020.
Thank you so much, Andre, and thanks also to the Russian Arbitration Center and to the Moot competition for having me here, at least virtually, on what's a very important topic. I very much appreciate personally the invitation and the opportunity to speak with all of you and to join Anna on such an important topic. I can't predict what's going to be the case, what the world is going to look like, either for international arbitration or for other things in 2030. I don't think I can even do it for 2022. I think if one thinks back to 2018, 2019, none of us would have predicted that we'd be doing something like this afternoon, this morning, or that the last year would have looked anything like it really did. So I'd begin with a note of modesty and caution about either the ability to predict the future, or even in some sense to evaluate fully the present. That said, I have a few observations about the past year and what it may mean for the future. You could imagine a world if somebody had told you 3 years ago that international travel would be next to impossible or very difficult, that people wouldn't be permitted to sit next to each other, at least not in any normal circumstances in a single venue, that most of our reactions, if you'd gone to the Moot or to Tilney Hall or to the Singapore International Arbitration Center's annual appreciation event and asked the audience, what would arbitration look like with these constraints? I suspect many people would have said, well, we'll need to take a pause. We'll lose a year. And as I think we all know, that in fact hasn't at all been the case. And Anna alluded to some of these things, but it's worth looking at some of the concrete figures, some of the real experiences. Every major institution has reported increased and sometimes almost revolutionary increases in their caseloads. It's true of the ICC, HKIC, LCIA. The Singapore International Arbitration Center will report a caseload that's almost doubled in 2020 from its previous best year, 2019. You could have imagined that there would have been a pause in international arbitration, but caseloads actually say the exact opposite. They say that there has been an acceleration, sometimes a very substantial acceleration. It's not just in terms of the number of cases filed, it's also in the continued progress of the hearings. You could have imagined that people would file lots of cases, a little bit like reserving room at your favorite resort for whenever it might open up again, not really expecting that the arbitration would go forward to a hearing, because as experience told us, hearings, at least the evidentiary hearings, were always in person. Maybe you'd have one witness after some argument appear on a grainy video screen, but in principle, a hearing meant an in-person hearing. It was almost as important, almost as fundamental as how you would, when you transferred land in the Middle Ages, transfer a clump of soil. And yet, as we all know, virtual hearings like virtual conferences are now the norm. People still sometimes fight about them, sometimes successfully delay an arbitration, saying, oh, there must, for this reason or the other reason, be an in-person hearing. And by in-person, they mean truly in-person, not in-person the way we're doing this, or the way the ICC interprets its rules. And arbitration has continued, has flourished during the pandemic in many ways. In many ways, it's become even more efficient, more expeditious because of the availability of technologies which have been improved, Andre, as you rightly say, at light warp speed in a lot of respects. In some ways, this was simply putting to use values, benefits of arbitration that historically existed. I like to think of those values, those advantages, as what I called the 5 E's. Arbitration is more efficient, more expeditious, more expert, more even-handed, and more enforceable than the competition and national court proceedings. This isn't probably the right forum to go through each of those E's, but they all arise from the fundamental character of international arbitration, where parties can choose the tribunal after a dispute arises based upon the specificities of both the parties and their individual dispute. There's an international enforcement framework, the New York Convention, and there's the fundamental value of neutrality and objectivity in the arbitral process. And all of those various values, efficiency, expedition, expertise, I think enabled arbitration to flourish, and to flourish better in many respects than the national court proceedings during the pandemic. Indeed, I think you can add a 60 these days. Arbitration is more electronic than the alternatives. And I think this conference demonstrates that to some extent. In a sense as well, if you think about this from a from more of a bird's eye perspective, arbitration has become more legitimate in some ways, again, as compared to the competition. What's the difference between a Zoom arbitration hearing and a Zoom national court proceeding? When you walked into a marble courthouse with judges robed and guards and court bailiffs and all of the impressive historical regalia, it had a different feel than when you walked into the Hilton Hotel and went into a basement conference room. The feel's not so different these days. There's not a lot to differentiate a Zoom hearing in an arbitration from a national court proceeding. And perhaps that too will contribute to the increase in popularity of arbitration in 2030. I think the real challenges come for international arbitration from a different perspective. I think the international arbitration community and businesses who are the drivers of that community have used the technology that is available to us to deal with truly a transformative event, the pandemic that fundamentally changed the rules of the game. They've done that successfully, as arbitration historically has successfully evolved. I think the larger question is, how do states, and in particular, how do the constituencies on the left and the right, perhaps one might say the far left and the far right of states, react to the pandemic and to international arbitration in the future? My own personal sense is that those parts of the political spectrum have seen the pandemic from their perspective necessarily as requiring enhanced state control over many aspects of people's lives, whether you can travel, how you can socialize, and the like. What will that do to what historically has been a dispute resolution process founded on individual consent, private autonomy, the decision of individual businesses? I don't know the answer to that, but I think one question, and one has certainly seen more than glimmers of this in investor state arbitration. I think one possible version of the future is that the state sees arbitration like socializing as a threat to it and to its monopoly on justice and the rule of law. I hope not, but for me, that's the major cloud on what otherwise would be a fairly sunny horizon.
Thank you very much, Gary, for this insightful views. And I think it's a really interesting and important question also for me, because it's for sure we're happy to hear about the growing caseload, but we also understand that it's pretty much the result of big work that was done by arbitration institutions, by arbitration practitioners in previous years. So it would be interesting to see indeed whether there will be kind of arbitration boom in 3-5 years when the arbitration clauses that were concluded during this 2020 and the times of pandemics will actually lead to particular disputes. So, and I do hope that arbitration is a more flexible, especially I think in the beginning of pandemics, it looked much more fascinating. Indeed, it became more preferable dispute resolution method during the pandemic. So I do really hope that we will have this arbitration boom, as I said, in 5, 3, 7 years, starting from today, arising from the clauses, when we will see the clauses that were concluded during the 2020, and we'll see, oh, it was this interesting time. So it's arbitration that was born initially, yes, during the pandemics. I would like to ask Anna your views on what do you think about these fundamental changes that Gary was speaking about, whether there is a threat for fundamental pillars that international arbitration is standing on, like flexibility, party autonomy, maybe there is a threat for system of enforceability of the awards in the future, because I think we heard some at least worrying notes in Gary's speech. So maybe what are your views? And I think especially it's interesting from the neutral point of view.
Well, thanks. Thanks for this question, and I hope that we will have an opportunity to get back to the issue of investment arbitration, because there I must say I do not concur with Gary. I concur with him on many aspects, but I would really like to have an opportunity to discuss that a little bit further. I think we are really at a juncture in the what you call the fundamental changes in arbitration, and I think that arbitration has all the ingredients to allow it to respond to the challenge that I see coming in the long run, because that's your question, you know, what are these changes in the long run? And I think in the long run, what we will see is a need for speed. And what arbitration has in itself, because of its flexibility, because of the party autonomy, the parties driving the process, because of the enforceability which is inbuilt in the arbitration framework, it has all the ingredients to be able to respond to these challenges. But what is really important is that both in the delivery, in the form of delivering arbitration services that I see evolving a lot, and also in the speed elements of the arbitration practice or the arbitration tools, we do not lose sight of these fundamental values which make arbitration what it is, and which make it such a useful tool that parties want to resort to. So indeed, flexibility, party autonomy, due process, neutrality that Gary was mentioning as well, enforceability are the core values that need to be protected. And they will need to be protected in the new tools for arbitration that we see developing, and maybe we shouldn't call them arbitration, we should call them dispute resolution in the online platforms. And that is a major change that I see currently coming from the East, which is that more and more trading platforms have inbuilt dispute or grievance management mechanisms, but that I would say is really the fringe of it. But there are more and more dispute resolution services that are offered on online platforms. And there is really, we have a partnership with Hong Kong's Department of Justice, where they have currently set up what I like to call a sandbox, but it's more a monitoring group to see what these developments are. They are exponential. They again have been boosted by the pandemic, and these services of online dispute resolution, or what we call online arbitration or online courts or online mediation, are really exploding in Asia. And I think there we have to be very careful to ensure that the fundamentals of a solid dispute resolution mechanism are not swallowed by the technology and by the efficiency and by the technology, particularly when you think about the role of AI in these platforms, because a lot of the services that are offered are heavily relying on AI. And when Gary was mentioning neutrality, one of the aspects of AI is that you can teach it whatever you want to teach it. So you can teach your machine to look at cases in a certain way or in another way, and the end user doesn't have a clue about what the machine has learned and how it has been programmed. So there are some core values that are the pillars of arbitration. We will have to see how they translate into these new developments that are trying to piggyback on arbitration, maybe arbitration, but may also be something totally different. So we may have to look at them very differently. And on the other hand, see how we can ensure that these core values remain. And the other thing, the other aspect I wanted to develop is the aspect of speed. What we see now is that almost every arbitration institution has its expedited arbitration rules. We are working in our working group too, that is actually meeting this week here in Vienna, and hybrid, in a hybrid form, of course. We have this working group finalizing the anti-trial rules on expedited arbitration. And we are talking about timeframes, 6 months and more or less, etc., which for some areas of business are still like a century. So that is where we will also have to see that the technology on the one hand and the needs of a tech industry, which wants its disputes to be settled immediately and preferably not by 3 wise men, but rather by a machine, because the machine is what they do. So they trust machines more than they trust us. So that this doesn't also disrupt arbitration practice by introducing this need for speed and by introducing too much technology. So what we will try to do in Ancitral, hopefully, is to continue to monitor the core values and ensure that they, whenever they are claimed whenever there's dispute resolution is claimed to be arbitration or arbitration-like or mediation-like, these core values are protected and preserved.
Thank you very much, Anna. I think it's very important, and it's great to hear that UNCITRAL is watching this issue closely, and I think it's also important for young arbitration practitioners to remember about this, because indeed in this very speedy and I think very efficient world that is procured by our digital colleagues who actually provide us with all these tools that are so fascinating for us, yes, and that we enjoy in order to make arbitration more efficient. But we shall not forget about fundamental things. Sometimes I think those colleagues can think about us as of some kind of those boring lawyers that making us or preventing us from moving quick enough in our digital economy. But I fully agree, and actually I think even before the pandemics we also had some discussion about online arbitration, and on each of these discussions where there was a lot of representative of digital online trading platforms and so on, I was also saying that you cannot cut this angle, yes, you cannot make it too much easy, yes, although maybe it looks not so fascinating and maybe boring for you. So I fully agree. I would like to have also maybe Gary's views on this and on where arbitration can be also helpful, because I think I was thinking about that apart from keeping those digital colleagues aware about those fundamental principles, I think it would be also very good to encourage them to use arbitration in their digital world still more and more. And it's not only about online trading, which I think began to evaluate even before the pandemic, but it's also about social media and new kind of disputes and conflicts that we are now having. I don't want to point to particular examples, but when I'm looking at them, I am thinking, well, I think arbitration could be a good tool here. So because sometimes you need emergency arbitrator to decide whether to block this kind of person who is registered in the social media or not, and who decides. I think that if arbitration will be not used and won't provide its efficient dispute resolution method based on these fundamental pillars, then I think the things that Gary was speaking about will become more apparent, and so the states could switch to their kind of regulation, saying that you cannot resolve disputes yourself properly, yes. And what we are seeing now, it's just some kind of decisions that are made by digital platforms or social networks themselves, and we don't see what is it based on. So maybe we shall encourage and we shall become even more active ambassadors of arbitration, not in traditional spheres like trade, finance transactions, but in this digital world. What do you think?
I think that's exactly right, Andre, and I think you raise a very interesting perspective on the use of AI and digital platforms. I'd like to start by sort of trying to be clear about how new technologies are used in different areas in different ways. Many of the online platforms involve what are effectively consumer claims. Someone buys something on Amazon or eBay or whatever the platform is, the way that a dispute about price or quality or something else gets resolved can be by a machine. Those are not disputes that historically could be resolved in most places by arbitration, with a few outliers, the United States being the most obvious one. Consumer disputes between a consumer and a merchant were not arbitrable, at least not subject to a.
Oh, you're freezing, Barry.
We can't hear you.
Courts, that national courts aren't really a very satisfactory way to resolve those types of claims, and that's not a criticism of national courts. If you have a claim for 100 rubles or 100 euro, it's pretty hard to figure out an efficient way to resolve that in anything like a traditional adjudicative mechanism. The time to order your Uber and to get to the courthouse has taken up most or all of the real value of the claim. And using AI or algorithms or some other sort of technology to resolve those disputes is in a sense bringing a form of justice to an area that perhaps historically didn't really have much justice. Small claims courts function, but one can question how effective given the costs they really were. Perhaps in that sense, the digital economy enhances the rule of law. That said, I do think it's really important to keep one's eye on the existence of different kinds of disputes, larger disputes, the kinds that I think most of the VIS competitors, most of us in the international arbitration world think about aren't those kinds of disputes that can properly be resolved by an algorithm. Fundamental to arbitration was the right to choose a tribunal. That's, I would suggest, a fundamental characteristic of arbitration. One of the hallmarks of party autonomy, one of the essential reasons that arbitration has the 5 E's, that it's more efficient, more expert, more expeditious. Equally, the right to a reasoned award, which in a sense involved transparency, perhaps not transparency to the public, but transparency between the parties and the tribunal, to understand what the other party's case was, to understand how it was that the tribunal had preferred one party's case to the other party's case, were essential to the guarantee in Article 18 of the model law of an opportunity to present your case and equality of treatment. An algorithm deciding your case using a formula that some government bureaucrat has programmed into the machine doesn't satisfy either one of those fundamental aspects of the arbitral process: the right to choose a tribunal, the right to a reasoned award, ultimately, I would suggest the right to a regular and fair process in which you have an opportunity to be heard. And I think in that sense, and this goes back to perhaps the cloud that I mentioned in my opening remarks, I think there is a threat if you take a tool that makes sense for small value consumer disputes and impose it on disputes that historically, for good reason, have required greater attention, where in order for the rule of law to both be effectively applied, but also be seen to be applied, you need individualized attention, and you need to be aware of what that individualized attention is. Online platforms don't do that, but they do give states a much greater opportunity to control in a variety of different ways the resolution of disputes and how and if the rule of law is actually applied. I think that, in truth, is a real threat for 2030. I hope it's not a threat that comes to be, but businesses are driven by the bottom line, and at the end of the day, they may make choices that compromise what in the long term they will see as their fundamental rights.
Thank you very much, Gary. I think now moving to some maybe forecasts. And you mentioned already, and Dana mentioned the work that is going on UNCITRAL expedited arbitration rules. So can you give some kind of maybe forecast in your views how maybe more traditional arbitration, not online dispute resolution, will look like in 2030? So whether it will be more institutional arbitration, or whether we will see some maybe returning back to ad hoc arbitration. How will the UNCITRAL model law look like? Maybe there will be also some changes, or maybe you don't think there are any changes needed. So, because I think we had the latest amendments in 2010. So in 2030, maybe we will need a new law. So maybe, I don't know, Gary, would you like to start?
I think that's a fascinating topic, and I'm not sure I'm the right one to start on this particular topic, whether there should be or could be a new UNCITRAL model law, or for that matter, UNCITRAL arbitration rules. I do think it is important to periodically revise arbitration rules as opposed to the model law. Every major institution does it. There are certainly aspects, including with respect to remote hearings, where even the best of rules, like the UNCITRAL rules, might benefit from a little bit of updating. I think modernizing the UNCITRAL model law is something where I would need some persuading. I need some persuading for, I think, 2 or 3 reasons. The first reason is, I think the last time we modernized it, we didn't necessarily move things forward, but perhaps moves things backwards, at least aesthetically. Article 17, which is about as long as the rest of the model law, although dealing with the somewhat incidental topic of interim relief and provisional measures, I'm not sure added a whole lot of value, with the greatest of respect to UNCITRAL. And therefore I'm skeptical about whether a future revision would in fact add value. Second, I think the model law, and this is one of its true virtues, is intertwined with the New York Convention, and to detach the two by changing in an important way the model law, I think would undermine what's been a very fruitful partnership in a sense. I think those two instruments, the convention and the model law together, provide the 5th E that I referred to, the enforceability of the arbitral process, arbitration agreements, arbitral awards. And I think moving the model law, which I think change almost certainly would entail, away from the basic framework of the New York Convention, and also, quite importantly, the precise words of the New York Convention, would in my view be problematic. And I think the third reason that I would hesitate, need a fair bit of persuading, is that old adage. I'm not sure it was Mark Twain, but somebody said it: if it ain't broke, don't fix it. And I don't think that the model law is broken. I think the model law actually works pretty well in practice. I spent some months in the years before the pandemic doing the very challenging hardship tour of persuading Pacific Island nations to adopt the model law. Fortunately, we had a good deal of success there. They had some minor additions in various points, addressing things like emergency arbitrator and perhaps refining the definition of public policy a bit, which on balance probably are positive, but I'm not sure that even those are necessary, and I worry that
we lost Gary. Hello?
I think Gary froze.
Yeah. Okay, so maybe while we are waiting for him to reconnect on, although it's very interesting topic. Oh, yeah, Gary, you're back.
I'd be skeptical as to whether there would be major revisions.
Okay. Yeah, thank you very much. Actually, I before our chat started, we had a quick talk, and you said that now in order to travel outside of UK, you need a good reason. So I actually thought that promoting New York Convention and Unity Trial Model Law among small island states is a very good reason, so that you can still use maybe in the time of pandemics, because otherwise it's a kind of threat to development for arbitration. So I think you should try.
We've had important successes in Palau and Tonga, as well as Fiji, and I would recommend all of you to think about those venues for your next arbitration.
Thank you very much. Thank you. That's indeed very interesting, and I think great news. And I'm always happy to see when the new states join either the New York Convention or the Unity Trial Model Law Club, I would say. Anna, what are your views on those issues that
well, I very much concur with Gary on this on looking at the Unity Trial Model Law on arbitration rules that indeed are more prone to or should be revisited or looked at more regularly than the two pillars of the New York Convention and the model law, which are really the enabling framework. And I really fully concur with him that I don't see a major need for fundamentally revisiting at least the model law. There are obviously for academic reasons people here or there that call for a complete overhaul of the New York Convention. The New York Convention is broken. We need to renegotiate it. Not so much. We don't hear that much for the model law. But you know, in any event, we are very much in the Secretariat in the good hands of our member states and of our NGOs and IGOs that participate in our work. So we'll do whatever we're told to do. But as personally, I don't think there is a major need to look into something which has worked very well and which works both for institutional purposes and ad hoc purposes quite well. When you see how these newcomers to the New York Convention are embracing the answer trial texts, and I would like here to pay a tribute to Gary and to his relentless energy in getting these countries from the Pacific Islands to join the New York Convention. As you say, we had a very good harvest in the last years. When I joined the answer trial 3 years ago, we were celebrating the 60th anniversary of the New York Convention. And at that time, I was talking about 160 states being, you know, my goal. And just last week, we got Belize. Of course, they're on the other side of the world, but also a minor small state, not minor, sorry, a small state joining the New York Convention. So we're at 167. So yeah, New York Convention, go, and model law, go. So for that, I'm pretty happy. But your question also included an important development that I would like to go back to, which is what is being done currently in UNCITRAL in its working group 3, not working group 2, but working group 3, which is the one that has been tasked with the reform of investor to state dispute settlement. So as you can imagine, it has not been very easy to go through the first stages of the mandate, which were to take stock of, look at what are the concerns, what are the real concerns, and what are the perceived concerns about investment arbitration, what are the state's views, but what are also other stakeholders' views about what is not working, and then coming up with a sort of a Chinese menu, if you want, with lots of different proposals and ideas and solutions, and then narrowing it down to where we are now, which is a third and hopefully last phase of the mandate, which is developing the reform tools. And here I would like to really quickly summarize where we are at, and maybe give a few comments and maybe also recommendations to the arbitration community in terms of, engaging more in this reform. So where are we currently? We have, if you want, two main streams that are being developed of reform. One, which is, I would say, more developing a suite of procedural tools that will fit, if you want, address a number of procedural issues in investor-state dispute settlement, such as, for example, multiple proceedings, reflective loss, shareholder claims, what you call counterclaims. So what you find typically in the dispute resolution chapter of a free trade agreement of the latest generation. If you look at the CPTPP, for example, all these issues are addressed in the dispute resolution chapter, and what is needed from this perspective is to make sure that these improvements will also apply to the 3,000 some existing treaties that are, of most of them, of an older generation, and that will that in order to keep this system coherent should have the same features in their dispute resolution chapter as far as these procedural issues are concerned. And then you have a more institutional reform that is on the table, and where I would say there are different elements, different types of institutional developments that are on the table, some that have a lot of traction for states, some that are not that, where there is a bit less of appetite, and I'm going to give you an illustration on that, and then a few other elements that we are working on. So there we have a proposal on the table to set up a multilateral investment court that for the EU is already part and parcel of some of its free trade agreements, and so is meant to replace, at least for the EU and its member states and its treaties, to replace the existing investor-to-state arbitration system. So the entry door through the ICSID Convention and through UNCITRAL rules adapted to investor-state disputes is not the favored entry door. What they want is that we build another entry door that investors would take to bring their disputes, and that door would be a first instance court and an appeals mechanism. Now, what we also see is that there is strong appetite on the part of countries and some notorious players such as China, for example, and Russia also, for that matter, is interested in setting up an appellate mechanism that would apply not only to the first instance court decisions made by this multilateral investment court that the EU is promoting, but also to arbitral awards rendered under the or that are enforceable under the New York Convention and the ICSID Convention. So this is where we are currently working together with ICSID on finding the means for example, Article 41 of the Vienna Convention, or that there may be means to ensure that although these awards are final and binding, they can still be subjected to an appeal, which would be rendered by a standing or a mechanism. This is not clear yet, but there is going to be, and I see that coming without a crystal ball and with a lot of modesty, that there's going to be an appeal facility. And in addition to that, there's also another institution building aspect to the reform, which is the establishment of an advisory center for developing countries to allow them to better embrace the investor state dispute settlement system, to manage their cases better, to possibly find defense services as are provided by the advisory center to the WTO, which represents states. And so we have already advanced quite a lot on this advisory center, which, as you can imagine, is very much called for by developing countries, particularly African countries that are very keen on, and some Asian countries as well, that would like this to be one of the outcomes of the global reform of ISDS. And in addition to that, we also have some elements that may not necessarily feature. Oh yes, I forgot to say that the delivery mechanism, the delivery tool for this reform, whether the institutional part or the procedural part, will be through a multilateral convention akin to the Mauritius Convention, which has the interesting feature is that it applies to the 3,000 existing treaties, and or the OECD BEPS Convention, which does the same thing for double tax treaties, which also applies to the host of existing double tax treaties. So this would be the delivery mechanism of these two pillars of reform, which are procedural changes and institutional changes. What this convention will also provide is for a flexible means for states to adhere to various elements of the convention. So what we see is that there will be, for instance, a first instance court, or there will be an appellate mechanism that will be set up, but not everybody will, by joining the convention, also join the appellate mechanism or the court system. So this is really, for the time being, very much a la carte before states will make their final decision of what they want to join. And so, as I was saying, this is the overall delivery mechanism for the reform. And there are a couple of other elements, for instance, strengthening mediation and ADR in investor state disputes, which don't really require a delivery through a convention, but that could be done. Or, for example, states put a lot of emphasis on dispute prevention mechanisms. This is something that could be better delivered through a model law. for example, model law that could be institutional and help countries set up the right institution and have the right communication channels internally, and share or benefit from good practice. And on top of that, we have also two elements that are currently more advanced as well. One is a code of conduct for arbitrators and judges. The idea is that we do not differentiate, at least at this stage, between the sitting judges that would be sitting in an appeals mechanism, an appeals court, or a first instance and second instance court, but would apply across the board to those who are making decisions in investment arbitration. And that, I think, is going to be quite when you look at it from the perspective of the overall reform of ISDS, it looks like a minor, what some have called a low-hanging fruit in the reform process. But I think it's going to be quite an interesting product. We are developing it jointly with the ICSID Secretariat. We've held a number of consultations on it. And the other topic I wanted to also mention is third-party funding, where we are also trying to come up with something which is not diametrically opposite to what ICSID is currently working on, so that there's still a bit of coherence there, but to regulate, to bring in more transparency, and to possibly allow some states to choose to completely ban the use of third-party funding in investment arbitration. So what is interesting, and what I wanted to develop a little bit further here, is to see that there are not very surprising reactions on the part of the arbitration industry to these reform efforts, but that they are generally fairly well embraced. For instance, apart from two or three I would say rather disgruntled voices of arbitrators with name and status, who said that, why would we have someone looking over our shoulders and telling us what we should do and how we should behave? We know that, and thank you very much. There hasn't been that much criticism to this effort, but and I would say the reactions we're getting now are really more from the, if you want, the arbitration cottage industry, where people are saying, oh, but how is this going to affect me? And I think that's going to evolve if people are genuinely engaging in these changes. Gary mentioned earlier that there's been quite an evolution in arbitration, in commercial arbitration over the years, and I think any system that is man-made, man-developed, and man-used is something that deserves looking at and improving and changing. What we're not doing in Ancitral is throwing the baby away with the bathwater. It's really not an either or. And I'm really I really would like to call on the especially on the young practitioners to contribute to these discussions, to be maybe more engaged through the NGOs that participate, or the IGOs that participate. Can be the arbitration centers, for example, the Russian Arbitration Center, and come with their views as practitioners, so that we, even if ultimately the decisions are made by the states, the voice of practice is really important, and Ancitral provides that in its form. And if I may, while I have the floor, I'd really like to come back to a point that Gary made in a recent intervention, that recent talk that he gave in January, I think, with which was focusing on this multilateral investment court as opposed to international arbitration. And I was rather surprised by a comparison you drew, Gary, between those who don't like investment arbitration and the fact that Adolf Hitler didn't like arbitration for states disputes either. And to me, that seemed like the ultimate sophism, you know, all cats are mortal, Socrates is mortal, so Socrates is a cat. The thing which says, you know, all the people who want to build something new are necessarily opposed to what is there, and if they are opposed to what is there, then they are bad people, is something that that made me a bit unhappy. But I was looking forward to the opportunity of maybe taking something that I'm taking out of the context of your talk, putting it back into the context would be a good opportunity. So thanks for that.
Thank you, Anna. I think it's obviously I will give floor to Gary, but I already noticed that you have some discussions in this topic already, and so I would like to ask Gary what do you think? And thanks very much to Anna for this really comprehensive and clear insight into what the working group 3 status is now. And it's, I think, really interesting, because if it all happens, I think it will really, we will see the results in 2030 years. So it's something really about 2030. But what will be the appetite of the states for this kind of dishes that Anna, as a very passionate chef, is suggesting now? So what are your views, Gary, and how you will respond to this?
And thank you so much, Andre. And let me start by congratulating UNCITRAL also for its work in the South Pacific. They played an important role in persuading Pacific Island states to both ratify the convention and adopt the UNCITRAL model law. Also critical to that effort was the Asian Development Bank, which has been doing a spectacular job in promoting the rule of law, both in the Pacific Islands and in Asia more generally. I'm a little surprised that Anna hasn't heard voices of criticism about the multilateral court or some of the work at UNCITRAL Working Group 3. I think, in fact, as her reference to my comments a month or so ago suggest, there have been quite serious expressions of concern about how history, standing in 2030, will judge what the states at UNCITRAL are attempting to do. I think we should start with a recognition that investment arbitration, investment law has played a fundamentally positive and important role in international life over the last 4 or 5 decades. There has been 3,000 bilateral investment treaties that have fashioned a nuanced and textured body of international law, a critical body of international law that at its root protects individual liberty, protects the rule of law, protects individuals like all of us, like the VIS contestants, against the most egregious types of governmental oppression, whether it's expropriation without any compensation, whether it's denial of fair and equitable treatment or denial of justice, whether it's naked national, religious, ethnic discrimination. Those bilateral investment treaties have included vitally important protections for human rights, basic civil liberties. They've had with them a hugely successful means of dispute resolution. International law is nice to write on the wall, but unless you have effective means of enforcing it, of giving it effect, it's just writing on the wall. There have been 1,000 investment arbitrations with awards that have created, I think, a deeply nuanced and textured body of international law that at the end of the day protects individuals, protects businesses and merchants, protects people like us against state oppression. That system has by and large worked, notwithstanding developing in highly fluid, highly contentious times. States, including in particular the states that Anna spoke so positively about, have begun to criticize those results. Some states have. What they want to do, I would suggest, is to roll back the rule of law. And in order to do that, they want to retake control over the dispute resolution mechanism by fundamentally changing it. And I note that Anna left this little bit out of her description, fundamentally changing it from a historic mechanism used not just for the last 4 or 5 decades, but for centuries, in which each party to a dispute selects one arbitrator, and then those 2 arbitrators or a neutral institution selects the presiding arbitrator. That guarantees the impartiality, the neutrality that Anna spoke about. What the multilateral investment court seeks to do is to change that to a mechanism where states choose all of the decision makers. And the avowed aim of that is to ensure that states will win more frequently. That is not effectuating the rule of law. That, if you stand in 2030 and look back at what we are doing today, what UNCITRAL is doing today, that is not advancing the rule of law and providing a fair, efficient, objective means of dispute resolution. It's doing the opposite. And I did not compare critics of ISDS or investment arbitration to the Nazis. I instead, and this is very important, I compared ideas and criticisms that were used in different periods of time. If one is going to suggest radical reform, as is occurring, if one is going to substantially dismantle a system that has worked for 40 years, one ought to be willing to think about one's ideas, to compare those ideas to what others with those ideas have done with them. I would suggest those sorts of questions ought to be asked by those who would radically alter or dismantle the existing system. I don't think a multilateral investment court is the way if states wish to retract the guarantees that they give to foreign investors. States are free to do that. They can narrow the scope of fair and equitable treatment. They can define the damages that can be imposed for expropriation without compensation. What they ought not to do is seek to effectuate those changes by taking control of what is a neutral dispute resolution mechanism. That betrays the rule of law. And when one thinks about consistency in that regard, there is a reason that there are 3,200 bilateral investment treaties that tailor the investment protections to what different pairs of nations wish to provide. It is because there isn't properly a one-size-fits-all mechanism that can be imposed upon all countries around the world. Look at what happened with the Mauritius Convention. Look at how many countries have ratified that. Next to none. And I would suggest what one ought to do is think about how to make a fair, neutral, and objective dispute resolution process, which we currently have, work better, not to replace it with a means of dispute resolution dominated by the states, selecting who they choose as the judges, who will decide a narrow set of issues involving those states and their interests. That's not justice. It's the opposite of it.
I think, if you allow me, that Gary and I will have to meet in 2030 somewhere in Fiji or in Palau or in Tonga and look back and see who has actually foreseen better what is going to happen in the UNCITRAL process and whether what Gary fears has actually materialized or not. Do we have a deal?
Yes, but I don't think we should let that preclude discussion now about the issues and about what advances the rule of law and what doesn't advance the rule of law. We can't wait to 2030 for that discussion to happen. Because I was struck, Anna, by your comment that you don't hear pushback, that you don't hear criticism of the Multilateral Investment Court. That if you haven't heard that,
No, of course.
you should hear it now. You should hear it now. And I would suggest it would be useful to have a debate about that topic today, not in 2030.
No, I get your point, and clearly we are hearing. First of all, we are hearing in among the members of Working Group 4 different appetites, and there is no clear consensus among the members of Working Group 3 that the solution is to get rid of the arbitration system and replace it by a multilateral investment court. So yes, that we're hearing clearly, and that's as I tried to explain, that is also not what we're doing in Working Group 3.
That's good.
A number of countries are actually in their submissions insisting on the fact that what they want is the international arbitration, investor-state arbitration system to be preserved and to be improved upon and modified. And for example, if you look at one of the submissions by China, you will see that what they call for is re-entry door through investor-state arbitration and an appellate mechanism. So they absolutely don't want to get rid of investment arbitration. And where I'm saying, of course, there's lots of debate and discussion about what the solution should be and what it could be, and whether it's going to be a one-size-fits-all. I doubt it very much, and I think that the flexibility that I was trying to show in the reform delivery mechanism is really going to be crucial to make sure that a number of states can actually join this reform effort, because for some, what is the ultimate goal, which is setting up a court, is not the ultimate goal of others. And if we want to keep them all into global reform, we'll have to make sure that it fits these different interests. So yes, hearing discussions, hearing criticism, criticism mostly at one solution. That is what I was trying to highlight, is that the criticism is currently very much against this proposal made by the EU to replace the entire system by a multilateral investment court. But that's not what we're discussing in UNCITRAL. We're discussing a lot more, and this multilateral investment court is only one solution, and there is a lot that is being built and reformed in Working Group 3 that is not completely reshuffling and reorganizing investor states, etc. But stay tuned.
Dear Anna, dear Gary, thank you very much. We are running a little bit out of time. So unless Gary would like to make some final remark, I would like to say that actually it at least, thank you very much for the discussion. And I think this last topic shows that we at least will have very interesting times and discussions during the next years. And I also see that still, I see some downside of this kind of online and virtual discussions, and I think we are really missing personal meetings, because in other situation we could continue discussing by the cup of tea or coffee or glass of wine, and maybe find some useful solutions. Now we have to switch off and go doing other things that we are doing in our offices. So I do really hope that either in 2021, earlier than 2030, you meet together, and maybe I also meet you. If not this year, then I really hope that next year in St. Petersburg, the St. Petersburg International Legal Forum will be held offline, and we will be able to meet and to discuss the new developments. And I guarantee that we will have a lot of networking opportunities to discuss it, not in formal venues, but also informally. And I'm sure that nothing will substitute this kind of meetings and warm discussions in the virtual world. So thank you very much for this really interesting and insightful discussion. It was great to hear you, and I wish you all the best, and also all the best to all our participants. And stay tuned.
Thank you again, Andrei. Thank you, Anna.
Thank you.
Bye-bye.
Thank you.